Hi everyone, welcome to the Capello Row webinar on JobKeeper 2.0. I can see attendees are coming in now, so I'll just wait a moment while more people are coming through. While I'm waiting for people to enter, you should see on your screen a presentation with the title JobKeeper 2.0. If you can't see that, then send me a quick note or a wave or a chat and let me know, and we'll try and address the technical difficulties. But otherwise, you should be able to see myself at the moment. And if you can't hear or see, then you need to adjust some settings. I can see some people are coming in now. So welcome to the Capello Row webinar on JobKeeper 2.0. It's been a couple of months since we've done a webinar. And unfortunately, it doesn't mean that things haven't been happening. It's been really busy, and lots been happening with, coronavirus and the response to COVID. But we wanted to wait a little bit longer than after the announcement to put this presentation together to make sure that we had all of the relevant information. So I'll get started now because I can see that most people are here. So welcome everyone. If you're joining us for the first time, I'm Sarah Capello. I'm one of the partners at Capello Row Lawyers. And I run the disputes division at Capello Row, and I also do a lot of matters relating to employment, hence the topic now of JobKeeper, which is obviously very relevant this day. Just some housekeeping rules. We are going to be conducting a live seminar, although it also is recorded so that we can send it around later on. But you're welcome to submit any questions at any point. We don't mind, interrupt us. We're here to answer as much as we can. We want to be a resource for our clients and our referrers. So submit any questions about JobKeeper throughout, even if it's not the specific topic we're presenting at the time, and we'll address the questions at an appropriate point. If you have a really detailed specific question, we are most happy to help, but we'll probably take that offline just so that we'll answer any kind of broader questions. But otherwise, get in touch with me and we can talk about specific responses to the legislation and the rules. The presentation slides will be sent out after the webinar and also put online, and we'll also follow up with a copy of this recording. So there's me, of course. Then I'm joined by two wonderful solicitors from Capello Row. We've got Joey, who's in our Sydney office. Hi, Joey.
Hey, guys.
Joey is one of our lawyers who's been with us for a couple of years, and he works on a lot of employment matters, and he brings a wealth of experience with employment and also general disputes. Then we have Laura Andreazza, who's in Griffith. Hi, Laura.
Hi.
She's down in our Griffith team, and again, she's in our disputes division, and like Joey and I, attends to a lot of employment matters. So just getting an overview of what we'll be talking about today. We've given a couple of webinars on the JobKeeper rules and then the amendments to the rules, which occurred in earlier in the year. So if you want to get a refresh on the previous rules and the framework of the legislation, then I would recommend going back to those webinars that we presented on, which you can access through our YouTube channel. I can send through the information if you wanted to get in touch with me. But I won't be talking about the JobKeeper 1.0 in a lot of detail. I will touch upon some key points because the JobKeeper 2.0 obviously uses 1.0 as the framework to then expand upon it. But really, what's new with the new JobKeeper is a couple of key changes to the legislation. I just want to kind of first point out, though, that JobKeeper 2.0 hasn't yet been legislated, so it's not yet law. They have a bill that's currently going through Parliament with some proposed extensions, but it's not yet legislation. It should be happening any day, very soon, although this is all just information that we've derived from the bill and also from the fact sheet from the Treasury.
I think it's the 7th of September. Or
yeah, thanks, Joey. That's quite right. That's the information I'm hearing as well. And we'll keep everyone updated on our website and also on our social media sites as to any information that's coming up with that. And also just so you're aware, Joey and Laura will be jumping in with some discussions throughout the webinar, and we'll be effectively setting up the webinar will be in 3 sections. Firstly, I'll be talking about the specific changes to the payments and the the extension relating to the declining turnover test. Laura will be talking about the JobKeeper enabling directions, and then Joey's going to be talking about some really interesting cases that have come out of the JobKeeper legislation. So, like I said earlier, if you have any questions about any of those at any point, just jump on in. So some of the key changes, firstly, there's the obvious extension. It's being extended from September until the end of March. And Laura and I were talking earlier today, and our understanding was that it was originally extended, obviously, because of the second wave, and also because there's a continued impact on a lot of businesses, and the government's obviously intending to try and keep people as employed for as long as possible. So you can apply for the JobKeeper 2.0 for the second wave of JobKeeper before the 20th of September, but that's the first date that the second part will then be given effect. There's a different approach to it, and I think this was a reaction to some of the criticism about the earlier JobKeeper, in that there was one size fits all. There was one payment, the $1,500 payment, that applied to everyone, irrespective of the hours or what you earned. You received the $1,500 payment. So the two-tiered approach has two prongs, effectively. The first is that there's two phases, and the second is that there's two specific amounts. I'm going to talk about that a little bit later, but that's the biggest change to the JobKeeper, as well as big changes in how the businesses are determined to be eligible to receive it. So the declining turnover test has changed, and it's changed from relying upon actual figures versus projected figures. And again, I'll talk about that a little bit further along. So just revisiting JobKeeper 1.0, this is the current JobKeeper scheme that's in place. I expect a lot of people are already quite familiar with these, particularly if you're joining this session now. I'm assuming that a lot of people have already applied for it, receiving it, and they've also got that background knowledge. But there are some 5 key elements of the JobKeeper which form the framework then for the extension. The first is obviously the eligible employees. You have to be employed within the JobKeeper fortnight. Under the previous legislation, you have to have been employed from 1 March, be over the age of 16. Casual employees were excluded, although there was provisions for casuals who were employed systematically for over a 12-month period. And the not excluded part, which I referred to here, if you can see, is referring to employees who are otherwise not receiving the paid parental leave from the government and workers' comp. Because if you're receiving those payments, then you're not entitled to the JobKeeper payments. The eligible businesses are the businesses that are carrying on business from 1 March, and obviously who don't fall within the exclusions. The basic declining turnover test was, and I put 30% here because that applied to most businesses where you had to show that there was a 30% decline based on projected monthly or quarterly figures. 50% for businesses who generated over $1 billion worth of turnover, and 50% for charities. Now, importantly, you only needed to prove eligibility once. So if you had a decline in April, then of 30%, then you were eligible. And then in April, as long as you've had that decline there, in May, if you didn't have a 30% decline, it didn't matter. You were still entitled to receive JobKeeper for the duration of the JobKeeper period, which is from 30 March until the end of September. One of the key components is you have to meet the wage condition, and this is that you pay employees, the JobKeeper eligible employees, the $1,500 per fortnight. This is a scheme that was really designed to be a reimbursement scheme, so it was important that businesses paid that amount to employees, notwithstanding any of the fact that they were being stood down or that they were on reduced hours. They had to receive the $1,500, and the government reimbursed at the end of the month. It's a one-in, all-in scheme where if you have one employee in your business who's receiving JobKeeper, they all have to receive JobKeeper. So there's been some readjustments to the foundation rules of JobKeeper. Before I get to those, some relevant dates to note. The first is that the JobKeeper 1.0 was designed to end in the 27th of September. An important announcement that was made in June was that the JobKeeper payments wouldn't be applicable to anybody who was in the childcare industry. So that ceased on the 20th of July. And then on the 21st of July, then there was a big announcement from the government that they would be extending JobKeeper and that there would be changes to how it would operate. There's two limbs of these changes. The first is that there's been a change to the eligible employees, and this is that under the current JobKeeper scheme, you can now include employees that have been employed from 1 July. So this this started in August. This was from the 3rd of August announcement, where they said under the current provisions, you no longer have to only include employees that were employed from 1 March. So if you put on a new person in June, and then otherwise determined that you're eligible for JobKeeper, as long as they were employed from 1 July and meet the other eligibility provisions, as I outlined earlier, then you can apply for JobKeeper for the August period. But the biggest announcement related to the extension, and that will take effect from the 20th of September once it's legislated. And as I mentioned earlier, the bill's currently going through Parliament, but it's not yet legislated just yet. So this is a bit of a matrix of what the changes are going to be, and I'll expand upon some of these, and if you've got any questions, then just jump in with some questions about it. But this is really a summary of what the proposed changes are going to be. The first is that there's going to be 2 relevant periods, and the first period is really the September quarter, so you're dealing with from 28th of September to the 3rd of January, and the amount, the wage condition is going to be reduced, and there's also, again, a 2-tiered approach. So the reduction goes from $1,500, then after the 28th of September, it'll then be $1,200. But that $1,200 is only going to apply to employees who work more than 20 hours per week on average over the 4-week period counted from 1 July. Sorry, there's a bit of a typo there. Ignore the 1 March. It's from 1 July. I'll fix that up before I send it over to everyone after the webinar. But for any employees or a business participant who work less than 20 hours on average per week, then they're going to be receiving a lesser amount of $750 per fortnight. So this is obviously in response to the criticism that was put forward about how people who otherwise were receiving less than, who were ordinarily paid less than the $1,500 per fortnight were getting an increased amount of bonus effectively from the government, which otherwise the argument was they shouldn't have been subsidising. So this is really designed to help businesses who've been severely impacted by coronavirus. So the continuation of this and the extension is really focused on those businesses, and it's designed to try and keep employees employed in their positions. But it also has to be some consideration about fairness and adopting an approach that's going to try and cover everyone as much as it possibly can, but have a little bit more structure. So the second phase, on the first phase, the new declining turnover test reviews the actual figures based upon the September quarter comparison. So this is your September quarter in 2020, compare it to September 2019 period. So the quarter would include July, August, and September. And as long as you can show a 30% decline in that period based upon your actual figures, and it's the GST turnover figures, then you will be eligible for it. So there is a little bit of a self-assessment process, given that ordinarily your VAT isn't lodged until after the September quarter, and as I stated earlier, you can apply to receive it from the 28th of September. But ultimately, the period will effectively have almost concluded before you're actually making the application. Therefore, you should have some actual figures to rely upon in order to determine whether you're going to be eligible or not. Then for phase 2, there's a further reduction in the amounts that you can receive. So this goes from $1,200 to $1,000 and from $750 to $650, and it covers the period up until the end of March. And again, you're looking at the December quarter. So it could be the case that you're eligible to receive it in the first phase and then not in the second phase if you don't meet the comparison test based upon your actual figures, or vice versa. You could receive in the second phase and not the first phase. So if there's no questions about that, I'll just move on to the next slide, talking about the declining turnover test. So as JobKeeper 1.0, there's a basic test, which is the 30% decline, or 50% for businesses over 1 billion and 50% for charities. But there's also the alternative test. Now, for the extension, it is the same as the JobKeeper 1.0, and effectively the Commissioner has discretion in certain circumstances. Now, I want to be very clear that it's not an unfettered discretion. The discretion is not to determine based on an individual basis any exemptions or any businesses that fall outside of the usual mould. There is a class of entities that the Commissioner will determine whether they fall within that class to allow the test to be amended so that the usual circumstances don't ordinarily apply. And for example, some of the entities that they've contemplated, or the structures rather that they've contemplated that would fall under the alternative test, would be entities that commenced after the commencement date, but who commenced after the commencement date, but ultimately who weren't operating before that, so that there's no comparison period. So, for example, a business that commenced in 1 January 2020, they don't have a comparison period to rely upon. Also, they've contemplated other structures such as businesses who have acquired or disposed of parts of their businesses, people who have restructured. So they give some examples about businesses who have had significant increases in their turnover a certain amount of time, a period that otherwise were quite unusual. And then as against that, in the 2019 period, businesses that are affected by drought who otherwise have a lower figure than otherwise they should have. So therefore, the comparison period isn't an accurate representation of the impact that they're going to have had from coronavirus. So the alternative test, there are some parameters around that, but they're the same as the JobKeeper 1.0. Again, if you've got any questions, then just shoot them through. But an important part, that's really the changes about the monetary aspect in the turnover tests with the proposed amendments, so the proposed extension. But a lot, what appears to have been glossed over in the media is that the bill actually proposes significant changes to the JobKeeper enabling directions. And the bill deals with predominantly the changes to the directions more than the extension. And this is what we want to talk about today, because it's not really as highly publicised as the monetary figures and the decline in the wage condition and the declining turnover test. So what Laura is going to be talking about, and I'll hand over to her in a second, is what these changes mean and what kind of effect it'll have, and in terms of how you can manage employees. So, Paul, Laura, I'll hand over to you from this point.
Yeah, right. So as we know, the first round of JobKeeper basically made some changes to the Fair Work Act that gave employers powers to give directions and make agreements with their staff in relation to hours worked and things like that. So this bill expands upon that. It deals with some of those that are already on foot and adds some more for employers who will fall off the JobKeeper essentially. So on this screen here is just basically the main changes that will come from it. I'll outline them briefly and discuss them in more detail on the next slides. But basically, the main ones are the stand down directions. So for employers who will remain eligible for JobKeeper, that mostly remains unchanged. But the big change that will happen is that for employers who fall off the JobKeeper, if they can show a decline in a 10% decline in their GST turnover, they will be able to make certain directions to their staff as well. And that goes for agreements as well. So that previously we saw that employers could discuss with their staff if they wanted to amend their duties and hours, place and time of work. They could do that by agreement, or they could direct their staff to do that. So that will be possible for people, for employers who fall off the JobKeeper scheme after September. One other big change that is coming in is that employers will no longer be able to request that their staff take annual leave. So under the current legislation, basically what we are able to do is direct staff to take leave if they have, I think it's at least 2 weeks balance of leave. They can direct they take a period of paid leave. The rationale behind removing this is essentially because the government recognises that anyone who wanted to take up this opportunity would have already done so that it's no longer required, essentially. So basically this is the legislation as it stands right now, and the only change to this from what's on your screen is basically point E, as I mentioned earlier, that the employee will not be able to be directed to take their annual leave. But otherwise, it remains on foot. So the biggest things that will need to happen is if you are going to give a direction, the employer needs to give at least 3 days notice unless it is agreed, unless a shorter period is agreed with the employee. And you must consult with them as well. So you must really explain the effects, things that are going on. You don't need to disclose commercially sensitive information or anything that's confidential, but you do need to explain what's occurring, and you need to take on board your employees' comments and things like that. And of course, you need to reasonably believe that the direction is necessary to continue the employment of one or more of the employees. What is changing this slide here basically refers to employers who will fall off the JobKeeper scheme. So basically, they are now able, well, as of 28th September, they will be able to vary hours worked up to 40%. So you cannot reduce your staff's employment hours by more than 40%, and their hourly rate that they're paid will remain the same. You can change their duties that are performed, the location of their employment, and the days and times at which they are employed to perform their work. They basically, what we need to show here is that the reason for the direction is the reason for the direction, it's basically have to have come out of the COVID-19 pandemic or the initiatives relating to the pandemic. So we need to be able to demonstrate that the effects on the business have occurred because of that, and that the directions are necessary because of that. And as I mentioned earlier, there needs to be at least a 10% downturn in income, and you have to actually get a certificate from an accountant or basically a registered tax agent to that effect if you're a larger business. So relevantly also, you can't prevent the employees from taking paid or unpaid leave. So if you have someone on paid or unpaid leave at the moment, if your business falls off JobKeeper, you can't then direct them to, you can't then direct that they be stood down. They would have to remain on their paid leave.
So Laura, sorry to interrupt there, Laura, but as you're saying, the terminology I believe they use is that it's a legacy JobKeeper business. So the legacy business can still rely upon the JobKeeper enabling directions as long as they show the 10% decline, but otherwise any current JobKeeper businesses who are receiving the full benefit of the JobKeeper with the extensions, then they can rely upon the standard provisions as they otherwise are. That's just a summary, but
yeah, just other than obviously the leave, the request for them to take leave, you can no longer direct your employee to do that, but otherwise, yes, it will remain as normal for anyone who remains on JobKeeper. The only difference, the other main difference here with the legacy employees are they need to be given 7 days notice. So it's up from 3, obviously, so that needs to be written notice, and the same consultation will apply to that. So this is the decline in turnover test that will basically be done for legacy employees, like Sarah said. So this is to assess the 10% decline. Basically, the relevant test dates for this are going to be 28 October 2020 and 28 February 2021. So on your screen there is basically the relevant periods. And again, it's a comparison period. So if a direction is to be given before 28th of October, the designated quarter that we're comparing to is going to be the 30 June quarter. If the direction is going to be given between 28 October and 27 February, the designated period will be 30 September. And then anything that's on, any direction that's to be given on or after 28 February, the relevant quarter will be 31 December. So as I said, an eligible financial service provider must issue a certificate to the effect that you have suffered a 10% decline in turnover. However, for small business employers and individuals, the bill contemplates just the requirement to provide a statutory declaration to that effect. There are penalties if you are lying in your statutory declarations, obviously, and also if you are deceitful to your accountant in relation to your downturn. If it is found that that's the case, then there are penalties for that. And of course, the federal court, if it is found that you haven't actually suffered a decline, you can those directions or agreements that you've made with your employee, sorry, that will be terminated. If you fail the test on 28 October or 28 February, immediately your direction or agreement with your employees will cease, and you have to on these dates, so the 28th of February and 28 October, sorry, and 28 February, you need to provide notice to your staff as to whether or not the direction is continuing or ceasing. And there are also penalties for that if you fail to provide that written notice.
This is, sorry to interrupt there, Laura, again, but this enabling JobKeeper direction also can apply to location as well. So this will apply if you've given the employees a direction to work from home or to work alternative hours. So you have to be really careful to make sure that you're analysing the current working conditions of your employees to see whether you can extend them beyond the final deadline. as to whether you'll meet the eligibility test, and if so, then give new direction or give them notice of a termination of a direction. So obviously the key factors, if you've given a reduction in hours or a change in the days that they're working, or a reduction in days, and that's when you're going to have to ensure that you meet the standards. Otherwise, you can be determined to be still liable to pay that amount of money because on the basis that you weren't entitled to make the direction in the first place. Yep. And if you don't have an agreement from the employee, then you will not be entitled to have reduced their hours under these provisions.
Yeah, relevantly, my reading of the bill, Sarah, is also, it relates also to those agreements as well. So if you've given a direction and you fail the test, you obviously, that direction will cease, but it relates to your agreements as well. So if you've made an agreement with your staff and they have agreed to work at a different location or to perform other duties, and then you fail the 10% test, that agreement also ceases. So even if you have their consent, if you fail the test, you can no longer provide that.
Yeah. So this is something, again, as I mentioned earlier, that has been quite overlooked, I believe, in the media hype. I don't know if Joey and Laura, you've got the same impression in the research that you've conducted, but it seems to be somewhat glossed over, in my opinion.
Yeah, there isn't much mention of it until you actually read the proposed bill, where they go in further detail in relation to the directions and whatnot. But when you look at the summaries, they just gloss over that and they say, okay, it's been extended and these are the new tier rates and things like that, but it doesn't go into any further detail.
Yeah, I have seen some newspaper articles that refer to this and note that the government and some people within government aren't overly thrilled by the idea that obviously people who have fallen off the scheme can direct their staff to work less hours. But the general consensus seems to be that Parliament are going to pass the bill because they don't want to sort of delay the payments being available. So while there may not be complete agreement over whether this should be enforced, it seems that it may get through.
Yeah, that's my impression as well. So this kind of leads us then to discussions about how the JobKeeper enabling directions have been working in practice and some decisions that have come out recently. So Joey's going to be talking about what kind of questions are being put to the Fair Work Commission and what the outcomes are. So I'll hand over to you now, Joey.
Okay. So this whole COVID-19 pandemic has, thrown up a lot of issues that have not been addressed in the past. Companies, having to require their staff to work from home or at other locations or reduce their hours or increase their hours in some circumstances, as well as, making sure they've got a safe work environment and all these sort of stuff. So it's in, uncharted territories, which also leads to businesses not knowing, what needs to be done in certain circumstances, especially during the, JobKeeper and the JobKeeper enabling directions. And, that has, of course, created disputes between employer and employee, and the courts has had to rule on some of them. Such as the slides show, casuals working additional hours or permanents working less hours, reduction or increases in wages and things like that. So I'll just go through some recent cases that have addressed these issues. And the overriding sort of factor that I've sort of gathered from all of this is it really comes down to what's reasonable, which will be addressed further. So there's the first case is one of the first cases that came about in that was handled in relation to the JobKeeper enabling directions, and it was a dispute between. So basically, this one, the employer had requested its employee they gave him a JobKeeper enabling direction not to attend work 1 day a week, and on those days they required the employee to take annual leave during this period until their balance would have been reduced to 2 weeks. So the minimum balance in order to get an employee to take annual leave needs to be a 2-week buffer. So the employee unfortunately refused this request and at the same time provided an annual leave justification as to why she didn't want to accept this request, and she relied on holidays that she had planned. Now, I note that it was not approved by the employer, and I'll discuss this a bit further down the track. But as well, on top of the the holiday that she said she had planned, she disclosed further personal circumstances in relation to her medical condition, which was not previously disclosed until such time that she was given this JobKeeper enabling direction. So there was a dispute. The employer wanted her to reduce her day and take annual leave, and she refused to do so. Now, of course, he went to the Fair Work Commission, and they had to resolve this dispute. And in particular, the Fair Work Commission determined that the employee's refusal of the request by her employer to take 1 day's annual leave per week was, by considering all of the circumstances, unreasonable, and they ordered for this employee to not refuse this request, and it was found that the employer was reasonable to make this JobKeeper enabling direction. Now, in making this determination, the Fair Work Commission noted a couple sort of points which pushed it into that direction. Now, the first one was the employee had combined annual leave and long service leave entitlements of approximately 18 weeks, which she had accrued over her 22 years of service for the employer. So basically, the Fair Work Commission said if the employee took 1 day of annual leave as requested up until the end of September, then she would still have 11 weeks of accrued paid leave as a buffer. So that was one instance where they found that she was unreasonably refusing to accept the JobKeeper enabling direction. And the other reason that the Fair Work Commission sort of observed was the employer specifically has a leave policy where employees are not able to book trips or make payments prior to this leave being approved by the company. This specific employee had gone about and booked a holiday without requesting permission by her company. So that as well worked against her. So
I wonder where she was going in this day and age, though, Joey. Where would she be?
Yeah, I don't know.
Sorry to interrupt. I was just curious.
Yeah, that is a good call. I don't know. Maybe she still had some hope that the borders won't, because this was a bit early on as well. This was I think it was around April. The matter was being heard, so maybe she still had some false belief she was going to Italy or something. I don't know.
Yeah. She probably wasn't from Victoria.
I don't
Sorry
know.
to interrupt, but yeah. So I guess it's a really good point to make that the annual leave requirements has been enforced by the Fair Work Commission to show that it's actually reasonable to require businesses to, employees to take them. Sorry, you were talking about the casual employees working additional hours.
Yeah. So but in that one, like I said, it all came down to the relevant test in that case was whether it was unreasonable for the employee to refuse the request. And in those circumstances, the Fair Work Court, FWC found that it was unreasonable for that employee. Now, there's another case in relation to JobKeeper enabling directions to reduce hours of work. In this specific case, the employer was a recruitment business for accounting and finance roles in Australia and New Zealand. And with this COVID pandemic, it significantly impacted its business. Now, in the circumstances, this employer issued JobKeeper enabling directions to its employees to reduce their hours to 12 hours per week, which in some cases resulted in a reduction of an employee's remuneration of up to 70%. So in those circumstances, that employer obviously went to the Fair Work Commission and they argued that 12 hours per week would not be sufficient for him to meet his role requirements. And further, if it was found that he was only able to work 12 hours per week, then in his role for the company, he would not be able, the company would continue to lose money. This was the argument he raised. He said that the company would continue to lose money with the reduction in his hours, as he would be unable to effectively steer the company back into the right direction and making the profits that it wanted to. Now, the Fair Work Commission in these circumstances found that where an employer can show that COVID-19 has significantly impacted its income stream and cash flow, irrespective of the significant financial impact to any employee. And in this one, that employee raised that he was a sole income earner and a significant reduction in his income would significantly impact his family. But in these circumstances, the Fair Work Commission found that, like I said, if an employer is able to demonstrate a significant income in reduction stream and cash flow, then a JobKeeper enabling direction to reduce an employee's hours of the work equivalent to the JobKeeper minimum is reasonable. Now, while a reduction from, say, he was working a 36 or 38-hour week to 12 hours, while the reduced working hours may impact the ability for this relevant employee to increase revenue for the company, the Fair Work Commission noted that it's not the Fair Works Commission's role to stand in the shoes of the employer unless the employee's position is clearly untenable. So in this specific case, it determined that the direction was reasonable. The Fair Work Commission relied on, in addition to various factors, the employer's position where they had a commitment to review the situation each month. So it wasn't this is going to be for the next 6 months, whether we make a profit or we make a loss, and too bad you're on 12 hours. It was being reviewed on a month-to-month basis. And the Fair Work Commission accepted the employer's position there. Now, there's another case. This one specifically goes to, it touches upon casuals and the like in relation to a JobKeeper enabling direction. It's in relation to the, it was initiated by the Union of Australia Queensland. Now, in this one, an employer made a JobKeeper enabling direction to its employees proposing a minimum of 25 hours of a 25-hour work week for all staff, full-time, part-time, casuals. The union, on behalf of its employees, argued that a minimum of 25 hours work a week unfairly and disproportionately impacted on the employees and the casuals. And in these circumstances, essentially, it wasn't fair. So the Fair Work Commission in these circumstances held that the JobKeeper enabling direction, directing all the employees to work a minimum of 25 hours a week, was not unreasonable, even though the direction would increase the hours of some casual employees, for example. While the union argued that the direction was unreasonable and disproportionate, the Fair Work Commission rejected this argument on the basis that the hours of permanent employees exceeded those of the casual employees. Also, it determined, in determining that it was not unreasonable to require employees to work extra hours, for example, being the casuals, the Fair Work Commission commented that if it had been Parliament's intention to prohibit an increase in work hours as a result of the JobKeeper enabling directions, it would have specifically put a clause to that effect in the legislation, but it didn't. So in analysing the legislation and making its decision, the Fair Work Commission said it was reasonable in these circumstances to allow the extra employees, allow certain employees to work extra hours. Now, this is contrasted to another case, and this is what I mean. It all centers on about whether it's reasonable. And if you've got the wrong intentions as an employer to give your employees extra hours simply because they need to work for it now that they're getting more money, then that's not the right approach. So in this next case, and it's the final case in relation to the JobKeeper enabling directions, a casual employee was effectively removed from JobKeeper by his employer after he had refused to work more than his regular hours. So in that case, the employee was a casual, he was a uni student, full-time uni student, Monday to Friday, and he did some casual employment at a resort bottle shop and typically worked probably one shift a week, about 9.5 hours on Saturdays. So with this this was another one which was a bit early on in the piece, with JobKeeper coming into effect. That employer sought requirement from his employee to work the extra shifts on the basis that he was now getting paid them anyway. And he wanted to effectively get his money's worth from this employee. So, but like I said, this employee said he physically couldn't because he was a full-time uni student and he could only do 1 day a week on a Saturday on a casual basis. So in those circumstances, the employer took him off JobKeeper, and he said he didn't want to pay him the extra money if he was only working the 9.5 hours. And this was a relevant sort of thing early on. I know some clients of mine, they were thinking, okay, well, If we've got employees that earn less than the 1,500 and work less than the 1,500, well then we'll just give them their entitlements, and we'll give other employees who work and earn more than the 1,500 the difference. Now this is obviously, you can't do it, and the Fair Work Commission has made numerous comments on this, and it's not the case. If for JobKeeper 1.0, if it's the case that a casual or an employee working part-time who normally doesn't earn $1,500 gets this $1,500, they're entitled to the full amount irrespective. But
so the practical problem with that ruling was because businesses had to pay this amount of money in advance. So they would go from, they're already being affected by coronavirus impacts, and they're going from paying a specific amount of salary to all of their employees each week or month or fortnight, however they have their pay cycles, and then increasing that amount to make sure that they're meeting the wage condition. Otherwise, they wouldn't be entitled to actually receive JobKeeper. And this is why I think one of the changes in the JobKeeper 2.0 has come about, because under the new scheme, that bottle shop would only be paying that employee the $750 and then the $650 because he would be less than the 20 hours.
Yeah. So I think part of it, and it's the government's, wants to sort of reduce or cushion the impact of the coronavirus. So they took swift measures initially for JobKeeper 1.0. So in those circumstances, they did like a one for all sort of approach. But in taking the criticisms and sort of amending it, this is like you said, has sort of caused the amendments to be made for JobKeeper 2.0 and the reduction in hours, and employees getting not the $1,500 if they're not working that much. But in that specific case, the employer did argue that he was making payments upfront each fortnight to its employees, ordinarily where they weren't entitled to the $1,500, for example, and it caused hardship for its business. Now, the Fair Work Commission, in that case, recommended that the employer reinstate JobKeeper for this relevant employee. He also commented, the Fair Work also commented and said that employees under JobKeeper are not ordinarily obligated to work extra shifts unless it was reasonable. And in this case, it was a student who was at uni 5 days a week, so it was reasonable for him to refuse this request, and it was unreasonable on the employer to make this request simply because he was earning that money anyway, and he wanted to get his money's worth. Now, the Fair Work Commission also asserted that, it made the point that, the employer was effectively receiving free funding from the ATO to pay its employees on JobKeeper, because this relevant employee threatened to remove everyone from JobKeeper. And it essentially made the comment that, the Fair Work made the comment that this was ridiculous in circumstances where he was effectively getting money from the government to keep his business running. So, I mean, that was the last case that I had to discuss with you guys. But in addition to that, there, as you guys may be aware, there's numerous awards that cover various industries, and in response to the COVID-19, in addition to the legislation, about 99 or so awards were varied in April, where the Fair Work Commission made determinations which included provisions for unpaid pandemic leave and annual flexibility. So what that meant was they included it's called Schedule X at the back of about 99 or so awards, where it inserted the temporary sort of provisions in response to the coronavirus. And what this means is it provided employees to access 2 weeks of unpaid pandemic leave if they met certain criteria, and the ability to take twice as much annual leave at half of their normal pay if it was agreed, if the employer agreed with it. Now, these amendments would up until the expiry date was 30 June 2020. So what's happened now, given that we're in August, is the Fair Work Commission has extended many of these awards, has extended the provisions for the pandemic leave for a lot of these awards. Now, each extension is different with different end dates. So I would recommend you have a look at the relevant award to see whether A, it's still in operation in relation to the pandemic leave provisions, or B, if it's been extended, what's the end date. You can easily find this on the Fair Work website. And I mean, just some examples of awards where it's not, the pandemic leave no longer applies anymore. The Clerks Private Sector Award, there's the Aircraft Cabin Crew Award, there's the Sporting Organisation Award, there's the Telecommunication Services Award. There's about 15 or so awards where it's no longer applies. So I would highly recommend that you go check that out if you're an employer that has employees under any relevant award, or vice versa.
Thanks, Joe, for that. Before we wrap things up, we just wanted to really quickly mention a very big and exciting decision that came down in the past week or so. It was a decision that was quite controversial at the time that it was made, and it was relating to personal leave. So Joey and I have presented some articles and some webinars on it previously, but this was the Mondelez decision, and this ultimately decided that personal leave was to be counted as a one-day, on a one-day basis, or per day basis, as opposed to an ordinary hour basis. So that decision has now been overturned by the High Court, and it's reverted back to its original status. So we're going to be doing some more articles about that, but I just wanted to touch upon that really quickly as an important employment update to note. But thank you. We'll start to wrap things up now. If there's any questions, then please shoot them through now. But we want to thank everyone for continuing to support Capella Row. We really want to aim to try and provide as much resources to our community as possible, and that's why we've got our coronavirus dedicated page on our website where we've been delivering articles and content. We've been busy also speaking directly with clients one-on-one to make sure that we can help them throughout this process, and we'd be happy to help anybody else who has any inquiries. A lot of the inquiries are employment related, and we also have a lot of queries about whether contracts remain on force, particularly given the force majeure provisions. We've also had a lot of queries about the mandatory code of conduct, which I'm not aware of any extension at the moment, but in my view, it potentially could be extended, but there's still a lot of arguments that are coming forward about landlords who are not extending that. Who are not giving the relief that they're required. So there's a lot of assistance that still can be attained, but people are resisting. So we're here to help in that respect. But Joey and Laura, is there anything else that you want to add about the JobKeeper 2.0?
Nothing.
No.
Thanks, guys. Wonderful job. And as I said, reach out to us if you need anything, and we hope to see you again all very soon. Thanks. Take care. Have a great weekend.
Thanks, guys.